Let's bring in two legal experts now to look at the law behind all this. Defense attorney Misty Marris, and Jeff Swartz, former Florida judge, professor of law at the Cooley Law School. Thanks so much to both of you. First to you, Jeff, tell us what the legal bar here is for basically proving or deciding between the two arguments we saw. From the prosecutors, this was an illegal attempt to influence the election. From the defense, they say, sure, influence the election, but just to protect his reputation, protect his family. What's the legal standard prosecutors have to meet?
Protecting his reputation and protecting what people think about him was exactly what he was concerned about when he was trying to get around this story interfering with his run for the presidency. So it's kind of a synonym for that. I also take a look at the fact that the defense basically admitted almost everything there is that's going to come on factually. And they're coming down to saying, well, he didn't do it to influence the election, but he did do it to protect his reputation. There's something about those two that come together. I wasn't particularly enamored with the opening statement of the defense. I thought it was rather haphazard. I thought that it went from one thing to another thing without a real chronological order or any kind of semblance of organization. The defense attorney who was addressing them looked more like a prosecutor who was just trying to answer a defendant's closing statement in rebuttal. I thought the opening statement of the state was very organized, very chronological. It was very direct, and I think it presented a lot of problems for the defense in this particular case.
Mr. Marris, it strikes me when a defense team stipulates, in effect, the facts of the case or many of the facts of the case as presented by the prosecution, it's because they know they got the goods, right? And they have a lineup of witnesses. They say they have text messages or recordings, et cetera, to back up their line of argument. But does that, from a defense perspective, is this a smart strategy here to then say, that's all fine, but it doesn't mean my client should go to jail?
It's really the argument that the defense has to raise. And that's because what is this case from the prosecutor's perspective? It's falsifying business records for the purpose of covering up another crime. And so for the Trump defense team, what they need to do is tell the jury that the NDA that Stormy Daniels signed is not a crime within itself, that the prosecution has to prove that intent to commit another crime in order for this to be a felony. To do so, Jim, what we heard the defense team present is that there's what's called a mixed motive. So yes, the NDA exists. Yes, Stormy Daniels signed it. Yes, money was exchanged. But the motivations to exchange that was not necessarily directly related to the election. It's related to embarrassment, his company, his reputation, his family. So that's what the defense is presenting. Whether or not that actually moves the needle for the jury, well, that's a question of fact for the jury to decide. But those are the central arguments that defense does have to present, because look, a lot of this is going to be in documents, right? This is going to be a very, very document heavy case. And so the defense is trying to frame that so that when the jury is viewing the documents and the witness testimony, they're remembering that theme which is presented in the opening statement.
Right. Jeff Swartz, I wonder, in your experience as a judge, how influential are opening statements in terms of setting the tone, influencing the jury, telling a story, it strikes me, in effect. They're prosecutors and defense are trying to tell a story to the jurors here.
I think it's important to the prosecution to set forth a story, to set forth what the evidence is going to be and how they're going to get there. I've never really felt that defendants putting on a particularly strong opening statement other than saying, we don't think the evidence will prove the defendant guilty beyond a reasonable doubt. We want you to look here, we want you to look there, and basically keep it short, which is why I think the defense opening statement was about half the length of the prosecution's. Because the prosecution carries the burden of proof, they need to get the jury on their side to start out with. The defendant only needs to poke holes in the case and try to find that one juror who buys their theory of the case. And that's all they're really looking for.
Misty Marris, I wonder, when you look at David Pecker and perhaps some of the other witnesses that we expect to come forward, Michael Cohen, perhaps even Stormy Daniels, not perfect witnesses, right? I mean, no witnesses are perfect, but in this case, does it present opportunities for the defense to, and we already got a taste of this, right? They're going to attempt to call into question their credibility.
Yeah, Michael Cohen's credibility will absolutely be questioned. Stormy Daniels, too. Remember, she did receive money in exchange for this. So credibility is always a central issue in the cross-examination of any witness. And when there's something to latch onto from a defense perspective, of course you do. I actually think David Pecker, look, there's going to be a lot of messages and witness testimony that really lays out what this catch and kill plan was all about. And he's going to be the one that's going to be able to talk about that. And that's really important because of that issue of intent. Now, from a defense perspective, you're going to say, well, guess what? He has a non-prosecution agreement. He's in an agreement with the prosecutors in order to testify so that he is not, in fact, going to be indicted on something. So that's always something the defense is going to bring up. But to that point, David Pecker has to be truthful. Truthfulness is a key component when it comes to a prosecution agreement. If he's not truthful on the stand, then he does risk actually finding himself in legal hot water. So there's always a yin and a yang, for lack of a better word, to every single witness. But of course, the defense goes hard on credibility, on cross-examination to any witness in this case.
Jeff Swartz, the first order of business tomorrow is going to be the question as to whether Trump violated the judge's gag order in terms of Trump, either in social media postings or his statements outside the courtroom here, by attacking witnesses or other members of the court in this trial. Do you believe prosecutors have a case for that right now?
I do. I think that the former president, the defendant in this case, is clearly testing how far he can go. I don't think $1,000 of violation is going to mean very much to Donald Trump. $100,000 of violation might mean something to him, but we're never going to get to that point. But somewhere along the line, the judge is going to have to, having been there, they keep pushing, they keep denying what you're doing, they keep basically just doing what you tell them not to. Or don't do what you tell them to, you have to get forceful. And I've had that circumstance where it came within about a hair's breadth of putting a lawyer in jail. And then all of a sudden he decided, he was calling around saying, is he really going to put me in jail? And other judges were saying, yes, you're defying him in open court. Yes, you're going to go to jail. Mm-hmm. And that's when he came in and did exactly what I told him he should do. Somewhere along the line, that threat has to mean something to Donald Trump. If it doesn't, he's just going to keep doing what he's doing.
No question. Well, Jeff Swartz knows a thing or two about running a courtroom. Misty Marris, to both of you, thanks very much. And still to come this